opening statements set for Tuesday. The Commonwealth intends to play a 15-second clip. What do you think, outside of court, we tried to ask Karen Read, what this clip could be about. She said she couldn't say. But do you have an idea of what it could be about, why they would want to play this in opening statements?
No, they have not given any of us a clue. So it's going to be a mystery to all of us, and it will unfold before our eyes. Generally speaking, people are using audio-visual aids and graphs and things like that increasingly during opening statements. The old theory that a picture is worth 1,000 words. So rather than just say what she said, they obviously have some point that they want to make and have her say it.
Now, opening statements, it's kind of like a roadmap for how the case will play out. Can you talk a little bit about opening statements and kind of what the point of them is?
First of all, a lot of people call them opening arguments, but they're not supposed to be arguments. They're supposed to be called opening statements, which means it is indeed a roadmap or a blueprint, just giving the jury kind of a big picture. This is what you should expect to hear. And we're laying out the whole kind of big picture thing here for you to consider. And a jury will then have to kind of hold you to that. Did you live up to your opening statement? Did you, in an opening statement, when you're laying out the blueprint for the entire trial and giving them kind of the big picture, you've got to then produce that during the trial. You can't promise things during an opening statement and then they don't hear about it during the trial. Opening statements are not considered evidence, and jurors are told don't consider them. It's just what the lawyers are saying off the top of their head on what they expect you to hear. But then you have to wait for the actual trial to begin to actually hear the evidence.
Now, the judge had ruled that the defense won't be able to use the third-party culprit. They won't be able to introduce that during opening statements. Is there a specific reason why? Is that common?
Yeah, very often judges may wait for you to actually introduce something as evidence, and you've got to show it during the actual course of the trial. They don't want you to promise things that they're not, that the judge is not sure about. So the judge will say, I will consider it when you actually bring evidence during the course of the trial.
No, the ARCA witnesses, yesterday there was a motions hearing, and it was another big topic again, these ARCA witnesses. We know there's been, some questions about the relationship with the defense. As far as there was a ruling today that they have to, or yesterday the judge had ruled that they need to let the Commonwealth know if there's any additional testing going on that ARCA is working on. Kind of what is your reaction to that? I don't know if you got a chance to kind of see the back and forth yesterday, but there was some concern that maybe there'd be some reports that would come in after the trial, and the Commonwealth was arguing that's not fair. Discovery needs to be met. Kind of what is your reaction to the situation?
Generally speaking, you want to present all the evidence beforehand, before the trial even begins, to give the other side a fair chance to review it. Sometimes, though, in the case of this ARCA evidence, they really did not have it until the last minute. So as long as you can justify why you're giving it kind of without a lot of advance notice, then it's going to be fine. But in trials today, we no longer have what they used to call the Perry Mason moment, where you can sort of do trial by ambush. You can surprise somebody with surprise evidence in the middle of the trial. You want to give it in advance to the other side, so the other side really knows everything that you're going to do beforehand. Both sides should be aware of the evidence that's going to be coming in during the course of the trial. So there's no surprises, and they'll be able to prepare in advance. And the only way you can give the other side discovery or information kind of at the last minute is if you can justify why there's reasons why it only became available at the last minute, and then it would be fine.
Mm-hmm. Do you think, I know the defense was kind of talking about they weren't able to officially hire the ARCA witnesses because they were first hired by the feds, but they didn't get the official word that they were able to late last month. Do you think that, if they don't know if these reports or other testings going on right now, do you think at some point the judge would let those testing or those reports into evidence down the road? Do you think that's kind of, like you had mentioned, a reason why?
Yes, I believe so. If they can justify why they didn't get a lot of advance notice on getting this discovery or information, then the judge, in all likelihood, in fairness, will allow it in, particularly if it's evidence that's going to be helpful to one side or another. And this ARCA information, these ARCA reports obviously are relevant and material. And so in all likelihood, they would be admitted as long as the defense can justify why they were unable to give it with not a great deal more of notice.
Mm-hmm. Is there anything else you think we should kind of be out on the lookout for in regards to opening statements? Do you think one side is going to come out a certain way and say something, or, I know obviously with Hank Brennan, new prosecutor in this case, anything we should be looking out for?
Wow. It's so hard to anticipate beforehand what they're going to say without knowing what they're going to say. I think in a general way, it's going to be rather similar in their opening statements to the original trial, because there's not an awful lot of new information that has come up since then, and we kind of know the positions on both sides. So I would not expect any shocking new thing to come out during the openings that we hadn't previously heard of.